I want to talk about actus reus and mens rea now. Under UK law, we've got basically two types of prosecutions. We've got a civil prosecution and a criminal prosecution. And in order to be successful in taking someone to court for a criminal offence or for breaching some kind of civil offence, you basically have to prove at a different standard. So, for example, under the criminal system, you have to prove beyond reasonable doubt. And under the civil system, you have to prove on a balance of probabilities. So if someone has breached a civil offence, then you have to prove on a balance of probabilities that that offence has been breached. And in order to prove that someone has breached a criminal offence, you have to prove it beyond reasonable doubt. Okay, so we've got civil offences and criminal offences. Criminal offences are basically what you think as being criminal: theft, stabbing, murder, that kind of thing. And civil offences are what you would generally regard as civil types of things. So, for example, most of the corporate law comes under civil, under the civil category. So, we've got the concept at criminal law that you, in order to be guilty of a breach of criminal law, you have to be guilty beyond reasonable doubt. This is the thing that you see in all the TV series when you've got the jury up there and you're convincing them beyond reasonable doubt, okay? But here's the thing. Under UK criminal law, in order to be guilty of something, you have to not only be guilty beyond reasonable doubt, but you also have to be guilty in the mind as well as the act. I.e., it's no use going around killing someone by accident. That's not murder. That's some other offence, maybe manslaughter or something like that. But in order to murder someone, you have to intend to murder them. In order to be guilty of murder, you have to intend to murder them and then murder them. In order to be guilty of theft, you have to intend to steal something and then steal it. If you don't both intend to do that thing and then actually do that thing, then under the criminal legal system in the UK, you are not guilty of that offence, although you could be guilty of a lesser offence. Let's say, for example, that you rushed in on your partner who was having sex with someone else, and you were so enraged that you just smashed that other person across the face, and oh my God, they died. Clearly that's not premeditated. Clearly you didn't go into that room intending to murder that person. You only went into that room intending to see your partner, maybe. So although you may have actually murdered someone, you're not guilty of murder because you only did the act, you didn't think of it. Now, under UK law, there's Latin terminology for this division of guilt, for this division of the mind and the act. In order to be guilty under UK law of a criminal act, you have to have the mens rea, which is the mind, and the actus reus, which is the act. Okay? So a criminal offence is comprised of two parts, the mens rea and the actus reus. And mens rea is spelt M-E-N-S, new word R-E-A, and actus reus is spelt A-C-T-U-S, new word R-E-U-S. Okay? So UK criminal law, guilt has to be proved beyond reasonable doubt, and in order to be guilty of that offence, you have to have the mens rea and the actus reus for that offence. Any queries or comments, put them underneath. Have a good day. Cheers. Bye.